Hi comrades, yours Kayveeyes. We are discussing repeatedly on many occasions on each and every developments taking place in the issue of notional increment to June 30th retirees. We are very much fed up. And every time when we are discussing, we could not say any improvement is taking place in settlement of this issue. In the Standing Committee meeting of the JCM held in September 2022, it was replied that decision will be taken based on the outcome of the SLP 4722 of 2021 in the case of Siddharaj, in which the interim stay order was passed on 5/4/2021. The SLP in the case of Siddharaj was dismissed in the Supreme Court on 19/5/2023. Subsequently, umpteen number of judgments which were delivered in various courts and even all the curative petitions in the Supreme Court were dismissed with the directions to implement the same to the similarly situated persons. Most of the judgments were very specific to implement the same to the similarly situated persons. On 26/6/2023, the DOPT informed that the issue is under examination in consultation with the Ministry of Expenditure. On completion of the process, action will be taken. In the meantime, various departments are causing orders to implement the same to the applicants of the court cases, treating the judgment or in personam. It was applicable only to the persons who have approached the CAT and also those who have filed the contempt petition in the court of law. Again, the issue was discussed in the Standing Committee meeting held on 15/12/2023. The staff side protested against the undue delay. The Additional Secretary informed that the issue is in advanced stage of consideration and the DOPT would take a decision in this regard very soon. The recently held SCOVA meeting on 22/2/2024, it was replied after mentioning the court orders that there was no reference to the relevant fundamental rules governing the annual increment. This was examined and the learned Attorney General was consulted. In pursuance thereof, efforts are being made to seek clarification from the Honorable Supreme Court on the relevant issues, including the rule provision which need elucidation. Action to implement the Supreme Court orders can be taken on the completion of the exercise. All these items we have discussed earlier. The intention of the government is very well known. It wants to drag on the issue by seeking clarification from the Supreme Court about the changes required in the fundamental rules, even though it can be done by the government itself, for which no permission is required from the Supreme Court. The government can decide to modify or amend the fundamental rules. There were many precedences also. Earlier, in the case of voluntary retirement, they were relieved in the forenoon of the same day. Now they have been relieved on the previous day. Amendments were made in the fundamental rules accordingly, even in the pension rules also. Accordingly, they can make, but they don't want to do it. But today, my concern is a very serious development has taken place in the railway department. They have issued an order on 25/2024. Even in the cases of individuals approaching the court in contempt cases, orders can be treated as personam with the restriction of arrears for 3 years preceding the date of filing the cases. A very dangerous decision restricting the arrears to 3 years. In support of the decision, they have cited an old judgment which was delivered on 13/8/2008, that is 16 years before, in the case of CA 51515152 of 2008, in which it is restricted the arrears to 3 years from the date of writ petition and it not to have granted the interest on arrears in such circumstances. They have just searched a old Supreme Court judgment and they want to apply the same to the notional increment cases because most of the pensioners, they are becoming due for more than 10 to 15 years. They are due after the changes of 2 increments. That is a due for them also. But in order to deny, they are searching on old judgment, Supreme Court judgment, and making it as an order. And the Railway Board has issued order to apply the said judgment and restricting the arrears for 3 years, and that too only for the persons who were the party of the case and filed the contempt petitions. Let us understand the cruelty of the government to deny the dues on one plea or the other. We should mount pressure to the government. It is not the case of pensioner alone. It is related to serving employees also. Around 15% of the pensioners and also the serving employees will be benefited if the order is implemented. The JCM staff side, instead of writing letters, he should bestow some special attention and exert more pressure on government, or otherwise definitely the aggrieved will curse all the forums which are all functioning as on day. If the aggrieved are forced to file a case separately again and again, and at this age, there is no meaning for the existence of the JCM, unions, and also the Pensioners Association in this case. This is my opinion. This episode is making only for the one issue about the Railway Board orders, which is most retrograde, that restricting the arrears to 3 years. A new way, a new path has been developed by the Railway Board by citing the 2008 Supreme Court order, which is very dangerous. That's why I am making this posting. With this, I am concluding, and moreover, there is no development taking place. We don't know whether they have referred the Supreme Court for change of FR and SR, whether any suggestion received, and what is the decision going to be taken. We don't know anything. But only because after seeing the railway order, it seems to be more retrograde, I am making this posting. With this, I am concluding. Thank you very much, comrade. Meet again.